State of Tennessee v. Charlie Martinez.
Good morning. May it please the court, my name is Chelsea Moore, and I'm here on behalf of the defendant appellant, Mr. Charlie Martinez. I would like to reserve 5 minutes for rebuttal. As the court's aware, there are numerous issues briefed in this case. I would like to focus on issues 1, 2, and 3 in my principal brief and 1 and 2 in the reply brief. Absent any specific questions on the other issues or an unexpected amount of surplus time. So, Victor Lettner died from a single gunshot wound to the chest sometime in February of 2021 and was discovered in an abandoned house on Kodak Road on February 17th, 2021. Kendra Ivey was the primary suspect in this case based on the initial investigation prior to the discovery of Mr. Lettner's body. Early on, investigators were able to track the cell phone data locations for Mr. Lettner's phone on an emergency basis. And those phone records showed that Mr. Lettner traveled from his home in Roane County to a hotel room in Strawberry Plains. That hotel room was rented by Miss Ivey. Miss Ivey knew Mr. Lettner from childhood. Their mothers were friends, I believe, but as Miss Ivey grew up, she got into some trouble, and eventually Mr. Lettner reached out to her to engage in sexual favors in exchange for money. So it was Mr. Lettner's birthday. He had reached out to Miss Ivey on Facebook, and they had arranged to meet.
I'm going to interrupt you just for a second. You have an outstanding brief.
Oh.
You have very fact-complicated issues. I want you to focus in on the issues you said you were addressing because you don't have a lot of time to address the issues that you said you were going to address. What I would like to hear you speak on is, I guess, the impact of the rap lyrics in this case. Why are they not considered statements against interest? And why do they not establish the defendant's identity in this case?
Well, it would be a multi-point argument. First, as I broke down the lyrics in my reply brief, I guess, let me rephrase. There are two complaints regarding the rap lyrics, or the writings. One being that the court allowed the state to introduce all of the lyrics, all of the writings, regardless of their relevance. And that ultimately allowed repeated use of...
Well, did you not also acquiesce? I'm not sure if you were trial counsel. When I say you, I'm just talking defense in general. Acquiesce in the admissibility of the entirety of the rap lyrics. If any of the rap lyrics were going to come in, did you or defense counsel not say at the top of the trial, then we want all of them? Because some of the rap lyrics clearly are not indicative or mirror the crime. Is that a fair assessment of the record?
If that is what the record shows, I would believe it. Also, based on my memory of trial counsel's performance, I believe that that's what happened. However, I do know that he attempted to suppress the rap lyrics ahead of time. So
Sure.
Ultimately, the court's admission of the lyrics is the primary issue, rather than suppressing them. And then we would add that the use of the lyrics in totality, especially during both closing and rebuttal arguments from the state, would be even further prejudicial because of the nature of the lyrics, the calling females curse words and one particular line, I just stuffed that bitch with pill and go straight to Kentucky. One, that's offensive on its face. That's offensive to most women. To most people, I would say stuffing somebody with pills to knock them out so that you can go on a trip to Kentucky. That would just be unsavory character evidence that would prejudice Mr. Martinez. Additionally, it has nothing to do with this case, as no one is alleged to have gone to Kentucky at any point in time. Further, 3 lines up from that, it references a woman named Megan, and there's no Megan in this case. So while the court ruled that these were, in fact, Mr. Martinez's writings, and I think it's difficult to say that writings found in his jail cell that mirrored writings found in the backpack are not from the same author, and they are from Mr. Martinez. However, the description of criminal activity beyond anything drug-related describes someone shooting Mr. Martinez in the leg and then Mr. Martinez shooting him in response in the gut, and it happening outside of a church. Those
And these things, I understand what the rap lyrics say, and we were talking about 3 different pieces of evidence, or 2 writings in the backpack, 1 in his jail cell, 2 writings that were recovered at the time that he was arrested, and 1 at the time after, obviously, in his jail cell. And I understand the trial judge did not make a determination of when these writings were made. The jail writings, clearly, you don't contest that they were relevant to the instant offense, the timing of when they were written and what they contain, excuse me, in terms of the jail writings pertain to the flight to New Jersey, correct?
Correct. And I guess I don't have a problem, I don't object to the timing part of the relevance, but again, I do believe that these are describing other types of crimes, made up or not, but they're not describing this particular crime, except for the fact that at some point Mr. Martinez did go to New Jersey and his face was on the news, but that was a result of Miss Ivy giving his name to police and police searching for him after the discovery of Mr. Lettner's body. The lyrics or the writings in the backpack are not as easily time identifiable.
The writing in the backpack, why should we ignore, or why should the trial court have ignored the writings that were, I guess, ancillary, and not the writings that were consistent with the crime? Dump the phone, dump the car, there were just...
Well, for one, dump the phone is one lyric, or is one part of the writings. Later in the writings, he says, sell a Glock, it's a hot 9. So there's 2 different types of disposing of the guns contained within the writings. Secondly, Ms. Ivy testified that both the gun and the cell phone were dumped in a body of water, but that body of water is essentially a small pond in the backyard, which sheriff's officers combed multiple times with multiple officers and never recovered a gun or a phone. Specifically, the phone was last traced back to after leaving Miss Ivy's Strawberry Plains hotel room, goes to the area of Kodak Road, and then goes back to Miss Ivy's hotel room. So the writings, the idea of dump the phone, dump the gun, directly contradict her testimony that the gun and phone were dumped in a body of water.
Well, what's the rule of law that we're talking about here? We're talking about 401, 402, 403? What are we talking about?
I would say 401 and 404B.
Okay.
Perhaps some 403.
So So these lyrics, you contend have no relevance and should have been excluded entirely based on the prejudicial value of them or because they're not relevant?
I would say that they were not relevant to this crime, that their prejudice vastly outweighs the relevance, any potential relevant value, because they discuss things that are not corroborated by the evidence independent of Ms. Ivy's testimony, and then they also contradict Ms. Ivy's testimony. So,
and under Britain and the most recent case law that is out there pertaining to rap lyrics, have we as a court required rap lyrics to be exact in order to be admissible? Are we requiring rap lyrics to be precisely the same as the crime in order to be admissible? Is that what you're arguing? Is that what you're asking this court to do? Because we've got pages of different lyrics, some that do mirror the crime and some that don't. You rely on the lyrics that don't. The state relies on the lyrics that do. So,
well, and I guess I do want to note that in my principal brief, all of the lyrics read from the closing are,
okay.
I mean, it's like 5 pages of the brief. It's a lot. And I believe I point out the lyrics specifically that the state attempted to connect to this crime, but the location is different. The only thing to say that Mr. Martinez was shot during an altercation with Mr. Lettner comes from Ivy. The physical forensic evidence from the abandoned home contradicts that any gunshot was fired into another person, period. So there was one gunshot fired in that home, struck Mr. Lettner, and went through his chest cavity, through a wooden door, through the wall, and into another room. Whereas, according to Miss Ivy, they struggled over the gun, and Mr. Lettner was shot, or I'm sorry, Mr. Martinez was shot in the leg at a close contact. It's unbelievable that a gunshot wound that from distance would travel through an entire person, wall, and door would just stop in Mr. Martinez's leg at close contact. So it's just a contradiction. I understand that the trial court felt that they were just basically describing the crime, but if this were Mr. Martinez sitting in a police interrogation room describing events that was later called a confession, I don't think that confessing these taken as confession would be sufficient to corroborate confessing to the death of Mr. Lettner, because it just contradicts the physical evidence that was found in this case.
But it doesn't contradict what she said happened, right? So he has these lyrics in his writings about being shot in the leg, so I shot the other guy. That's my paraphrase. And that's what she said happened. So those two do not contradict each other, right?
Correct. But her testimony must be independently corroborated in order to be true. And if these two things corroborate each other, but other evidence independent of this contradicts it, then I would say that it doesn't matter that these writings corroborate her story, because both are untrue.
I agree with you. I think those are two separate issues, so probably need to be careful in your argument, not mixing that. But I'll let you continue.
Well, and I guess another, if I can remember, another point that I wanted to make was that there was a lot of discussion about the cleanup in this case. Everything was cleaned up. once again, the physical evidence that was discovered in this case did not match what Ms. Ivy said happened. And specifically with the gunshot wound to Mr. Martinez's leg, an officer testified that it looked about a week old. And that was at least 3 to 4 weeks after Miss Ivy said that Mr. Lettner was shot. So if the gunshot wound to Mr. Martinez's leg happened a week prior to them arresting him, then that couldn't have happened during the altercation with Mr. Lettner. So Miss Ivy may have known about certain things that happened to Mr. Martinez after, but that just doesn't corroborate the crime that was charged and the crime that he was convicted for. So.
All right, thank you, Counselor. General?
Morning, Your Honors.
Morning.
May it please the court, Garrett Ward on behalf of the state of Tennessee in the matter of State versus Charlie Martinez. Your Honors, as my friend on the other side did, I'll focus my time on, I think, what's probably the central issue in this case, which is the admission of the rap lyrics. I think just to start off, I'd like to clarify what I at least took Mr. Martinez's challenge to the rap lyrics to be. At trial, in his motion in limine, he presented an authentication and a 403 challenge. So I think we're sort of properly addressing this, at least in issues that are preserved under either authentication or 403. I take my friend on the other side to be presenting only that 403 of those two preserved issues. So I'll focus on 403 here, and I'll acknowledge from the off, Your Honors, that this court and numerous other courts have recognized that there's some inherent danger to sort of the interest of justice in the use of rap lyrics, which these three writings do appear to be. I haven't heard them perform, but they certainly look to be rap lyrics.
So I've read them on paper
Yes, Your
in
Honor.
your briefs, and I've started to try to look at the record, but how are they contained? Are they on a disc?
They are photographs of notebook paper. So there were two notebooks recovered at the house where Mr. Martinez was arrested, and then there was sort of a sheaf of loose leaf paper in his jail cell. All the pages of both of those notebooks were photographed and introduced as collected. And I apologize, Your Honor, I forget which exhibit number it is, but there are sort of collective photograph exhibits of both notebooks and the loose leaf from the jail cell.
So
they
Mr.
were.
Ward, thank you for explaining that. If the rap are the rap lyrics the only evidence of the defendant's identity in terms of corroborating the accomplice's testimony?
I would say they're not the only evidence of corroboration.
What else?
I would point to both some DNA evidence in this
Okay,
case.
so defense says the DNA could have been placed in that car at any point. How is that?
So I take the sort of upshot of the witness corroboration rule as it was at the time of trial. It's obviously been abandoned at this point by the Tennessee Supreme Court. But at the time of trial, the upshot of the witness corroboration rule was that we're looking for sort of a modicum of evidence. I believe this court has also described it as slight circumstances corroborating identity. And what I take this court to mean by those words that corroboration is a low threshold. So perhaps there are other explanations for the presence of his DNA in this stolen vehicle, but when we're looking at this low threshold for corroboration, we're talking about a modicum of evidence. I mean, this court could scarcely have used a word that would have described a lower threshold than perhaps scintilla. So when we have...
I agree. It's very, very low. So the DNA and the rap lyrics.
I'd suggest also just some physical evidence in the case, namely the gunshot wound. I understand that there's some others, that there's perhaps some questions about the timing of the gunshot wound, but if Miss Ivy's testimony is, which it was at trial, was the perpetrator of this crime during a struggle was shot in the leg, and there's a pretty fresh gunshot wound on Mr. Martinez's leg, I think that's a modicum of evidence or a slight circumstance suggesting he
But
might.
of identity?
That he might be the perpetrator. If what we know about the perpetrator is that
That's-
he received this wound and then Mr. Martinez has this wound, I think that's slight circumstances. But certainly the rap lyrics here were an important part of the state's corroborative case. I mean, I don't want to hide the ball from the court. I actually want to be very upfront about the state thought these rap lyrics were good evidence of corroboration, which I think is fair, and I think actually speaks to their admissibility, because what we see both on principal closing and rebuttal closing is the state is directing the jury to look at these lyrics as corroborative evidence. So I certainly don't want to deny to the court that they were corroborative evidence. But I think as we analyze their admissibility under the Britain framework, what Britain sort of principally focuses on outside of the inherent danger in using rap lyrics is sort of these two ideas that can lead a set of lyrics to be more probative and thus more likely to be admissible. One is timing. In Britain, the video at issue far predated the crime we were talking about. Well, we don't have that in this case. I take there to be very little, if any, challenge to timing here. Certainly the timing of the jail writing is, I don't think there can be any dispute that was written after the crime. And as far as timing of the two notebooks found at the house, this is the house where he was hiding out after he returned from his flight to New Jersey. The writings are found alongside some materials that the testimony throughout the case indicates was used during the flight. So here we have strong evidence that these writings were penned after the crime at issue, something this court said was not present in Britain and was thus a reason to not admit the evidence. But perhaps most importantly, what I'd say the sort of central lesson of Britain to a prosecutor thinking of potentially admitting rap lyrics is they better mirror the crime charge. They better speak to the crime charge. And these ones absolutely do, Your Honor. I point in my brief to a number of, I think, pretty unique similarities between some of the violence described in the rap lyrics and the crime charge. So this isn't, the reason that's important is this removes us from Britain, where the video just described several sort of wanton acts of violence that had no factual similarity to the actual crime charge. But what do we have here? We have something entirely different. We have a set of rap lyrics that describe Mr. Martinez writing in the first person saying that this guy shot me in the leg and then I shot him in the gut. That's pretty similar to what we have here. We have a gunshot wound on Mr. Martinez's leg, and then we have a gunshot wound to the torso of the victim, Mr. Letner here. Admittedly, Mr. Letner shot in the chest, not in the stomach, but I think when we're looking at does that mirror the crime? Is that similar to the crime charge? I think it pretty clearly is. But the lyrics go even further. The lyrics describe in detail his flight after the shooting from Tennessee to New Jersey, staying with his cousin, going to visit his cousin with a bullet still in his leg. Well, that's exactly what Ms. Ivey testifies to, that after the shooting, she and Mr. Martinez fled to New Jersey, where they stayed with Mr. Martinez's cousin, where Mr. Martinez's cousin on his kitchen floor, removed a bullet from Mr. Martinez's leg. But there's even more here. The lyrics describe I guess Mr. Martinez's plan or desire, or perhaps in his mind, the necessity of disposing of certain pieces of evidence, dumping the gun, the phone, the car, the gun and the phone, the gun used to kill Mr. Letner, the phone that belonged to Mr. Letner, never found in this case. What Ms. Ivey's testimony is that Mr. Martinez ordered his sister and her boyfriend to get rid of those pieces of evidence in a nearby body of water. In fact, they were never found. As for the car, it was certainly dumped. There is surveillance video introduced at trial showing that car being abandoned at I believe it's a Home Depot parking lot in Virginia, hours away from where this crime was committed. And I don't want to belabor the point. There are more similarities between the lyrics and the crime here. And I think what that means as we analyze this under Britain is the trial court was presented with a set of lyrics that really closely mirrored the crime that was charged. And what is it to do in that situation? The trial court needs to, as it did, look at these lyrics and conclude, essentially, were these autobiographical? Are are these about the crime before me? The trial court makes that finding prior to admitting this evidence, which is exactly what it should be doing under the Britain framework. So I'd suggest to this court that given the high degree of similarity, given the evidence that we have about the sort of temporal relationship between the writings and the crime, that the trial court properly admitted them because they were writings about this incident that were written after the incident occurred. But at the very least, even if this court has some doubt, or even if this court may be thinking, well, maybe we wouldn't have admitted this, I'd strongly suggest that at the very least, reasonable judges could come to different decisions about whether or not under 403, which is a discretionary framework, whether or not this evidence should have been admitted. And if reasonable minds can differ, that is perhaps the strongest indication possible that the trial court was within its discretion in admitting the lyrics.
In response to Judge McMullen's question to your friend,
Certainly.
how did it, I know a motion in limine was filed and the court said it was inclined to introduce some of them, but tell me how it worked in the record where there was acquiescence to the admission of all the writings.
And I'll Judge Wilson, I'll give you the answer. To the best of my recollection of the record, to the extent the record is inconsistent with what I recall, I'll certainly cede to it. My recollection is that the indication from Mr. Martinez's trial attorney, who was different from his attorney here on appeal, was sort of, well, if some of the lyrics are going to come in, I think I'd like the whole thing. And I think to some degree maybe that makes sense. Maybe it is perhaps more damaging to your client for the jury only to hear his writings that more directly speak to this. It perhaps, as an attorney, removed your ability to say, this is just sort of braggadocious rap lyrics.
I guess for my concern was the other parts of the lyrics that could have been redacted.
In your honors, I think that's just an issue, Your Honor, that's just an issue that's not been presented to this court. What I can certainly say from the record, even if there's not formal acquiescence, is there is no effort by Mr. Martinez's trial attorney to redact these lyrics. We'd be having a slightly different conversation if that were the case. But given that the principal and sole objection raised to these lyrics was against their admission in their entirety, the question of whether or not perhaps the court could have redacted portions of them isn't properly presented to this court.
I want to switch gears just for a
Certainly.
second. The motion for new trial and the issue concerning the raising of the ineffective assistance of counsel at the motion for new trial, and all of that, there's a lot going on there.
Yes.
Seems like my brief review of the record and the briefs in this case seems like counsel was trying to address the issues that she's now addressing in the brief, and the state is saying, well, none of that's in the record, when she was prohibited from doing so at the motion for new trial with the ineffective assistance of counsel issue.
I don't think she was prohibited from doing so, Your Honor. Had Mr. Martinez's motion for new trial counsel presented an ineffective assistance of counsel claim, perhaps some of the materials that I take Your Honor to be referencing the sort of meteorological and the...
All of this is dealing with the timing of the victim's death, which I believe defense is arguing is central to their sufficiency of the evidence claim. And none of those, I guess, the expert, and they were not permitted to testify.
So a couple points on that. Mr. Martinez filed sort of this motion for this voluminous post-trial discovery, which I take to be this material that would have spoken to time of death, and he stated when he was sort of seeking this that this time of death material was relevant for two things: ineffective assistance of counsel, a claim that was abandoned and not presented, and sufficiency of the evidence. And Mr. Martinez is just wrong that this material that was not presented to the jury is relevant on sufficiency review.
Okay. Well, in her brief, she talks about the medical examiner's report and things, and all those things were presented to the jury, albeit not argued for the skin slippage issue, which she was, again, arguing should have been, her expert should have been able to talk about from the medical examiner's report. There were issues that were, which I didn't understand why the state didn't give the information I didn't understand what was going on at that level. I didn't understand why there was no, first of all, handing over of the evidence pursuant to either 16 or 28, or, I mean, it just seemed like there was a lot of frustration at the motion for new trial level. And defense counsel, if I recall correctly, filed their motion. State didn't respond for 9 months.
I believe that's correct.
Then when the trial judge is in a position to say, hey, this has been on my docket for almost a year now, we got to move, the state refused to hand over the information. So defense counsel was in a position to have to abandon the ineffective assistance of counsel claim. And if the state would have responded, at the time defense counsel had filed their motion, then that 9 months would not have played into the trial court's concern about its docket and getting the case moving, because it had been getting old. Mm-hmm. So I guess I'm that issue concerned me, because there's nothing wrong with raising an ineffective assistance of counsel claim at the motion for new trial level if you can establish ineffective assistance of counsel.
Certainly.
And here, they clearly were angling toward an issue of counsel's failure to point out problems with the timing of the death. So I guess, and I was waiting to hear her argument, but she ran out of time. I guess I didn't understand I know your response on appeal is none of that comes in, and you're probably right. But it seems like there was a lot of frustration, and it was all in large part because the state refused to respond.
So a couple of points on that, Your Honor, and I'll apologize from the beginning. I think to some extent I'm not going to be able to explain to this court why exactly this issue played out the way it did. Not to give a response that I know this court finds frustrating, but I wasn't counsel for the state at trial, so I can't speak to why there was this delay in responding. But once we do get to the response, the state's primary contention is that when the motion for post-trial discovery was initially filed, that there was no explanation of why it's an incredibly voluminous post-trial discovery request. It is.
I mean, I don't. Again, it's been a minute since I've been in a trial court and practicing, but the state just, to me, it has to comply with the discovery rules. I don't understand
what Rule
why
6?
it's voluminous. If you comply with the rules, you just turn it over.
What Rule 16 says is the state, at least the portion of Rule 16 invoked by Mr. Martinez, is the state needed to turn this material over if it was, I believe the specific verbiage of the rule is, material to the defense. Well, when the request was initially made, there was no explanation of why it would be material to any issue presented on the motion for trial. And that's initially, I think the trial judge indicates he's going to deny it because he doesn't understand why it's material. Then there's an affidavit submitted by the retained expert.
Well, the trial judge here had given money for them to get an expert on this issue before the state.
Certainly,
so
Your Honor.
again, if the trial judge made a finding that they were entitled to expert funds for this witness to come in, and then said, no, you can't have this witness because we need to move forward in the interest of time.
The court didn't say you can't have this witness. The court said the witness certainly had some amount of materials. The expert witness thought that maybe she needed more materials to sort of do her job as was laid out was approved by the trial court. And what the trial court says is, well, you need to explain to me why all of these materials, as Rule 16 says, are material to defenses you wish to raise. That's what Rule 16 says, that a party requesting discovery needs to show to be entitled to these sorts of materials. So the trial court initially says, okay, I gave you this expert. I don't understand why you need this additional material, so please explain it to me. It's suggested that it's necessary for sufficiency of the evidence, but this is primarily material. I understand that there was going to be some interpretation of material presented to the jury, but that interpretation, sort of the attack on the medical examiner's report, skin slippage, things of that nature, that wasn't presented to the jury. So this new information from this expert isn't relevant to sufficiency of the evidence, which is the one ground that Mr. Martinez said, that this material is material.
And the ineffective assistance of counsel.
And
claim.
effective assistance of counsel. And that ground is simply abandoned. I understand it's abandoned when the trial court says, look, I'm not gonna grant you a continuance, but it's not pursued. Mr. Martinez is fully entitled, if I can have a moment to finish, he's fully entitled to pursue that ground on post-conviction. And I suspect he will. But here on direct appeal, Mr. Martinez has said this is relevant to sufficiency and ineffective assistance. He's wrong with regard to it being relevant to sufficiency, because sufficiency review is cabined to the information introduced at trial, and then the other ground was abandoned. If this court has further questions, I'm happy to answer them.
Nope,
Thank you, Your Honors.
you're welcome.
I'll go ahead and start at the end, as I was there. I think it's fairly raised and clear in the record that the ineffective assistance of counsel claim was intended to be pursued. The trial court ultimately denied the specific discovery request, in part due to the timing issue, and then also refused to grant a continuance for trial counsel to come in and testify. So at that moment, Mr. Martinez was left with the option to either argue ineffective assistance of counsel without evidence and then lose that issue on post-conviction, or withdraw the issue pursuant to the court's rulings and save it for post-conviction. So while Mr. Martinez believed that, based on some of the things raised in these briefs, he could make an ineffective assistance of counsel claim on direct appeal, though rare, he was ultimately denied that opportunity by the 9-month delay from the state and the then denial of any kind of continuance to allow Mr. Martinez to present that proof. But the panel is correct in that that was going to be part of this. Now, going back to the other issues, I do want to note that the writings in the jail cannot be argued that they weren't written in the jail, but the writings found in the backpack in the home at the time of Mr. Martinez's arrest could have been written at any time, and therefore the writings in the jail that mirror the writings in the backpack could be someone rewriting work that they've been working on for months, years, however long. It's just because they were written in the jail doesn't mean that they are written about Mr. Lettner's death. It just means that they are a continuation of the development of the writings in the backpack. Once again, the reference to the gunshot wound to Mr. Martinez's leg and then the gunshot wound to the other person's gut in the lyrics are fundamentally contradicted by the actual evidence, the actual independent evidence in this case, because gut and chest are two different places. The state tried to convince one or more witnesses at trial that they were basically the same thing because they're so close, but they're not. They're very different. And once again, there's no physical or forensic proof that any blood from Mr. Martinez was found in the home. If he's got a gunshot wound that is bleeding, while he's walking out of the home, presumably there would be blood droplets. There are blood droplets throughout the home, but that blood is not Mr. Martinez's blood. Further, the DNA evidence from Mr. Lettner's vehicle, Mr. Martinez's DNA is found on his seat lever to get into the back of the vehicle, and then on the butt of a cigarette that was found in the back of the vehicle. Both of those DNA samples obviously point to the identity of Mr. Martinez, but they place Mr. Martinez in the back of the car, not in control of the vehicle. Being unknowingly in a passenger in a stolen vehicle is not a crime. If Miss Ivy stole the vehicle, picked up Mr. Martinez, and they drove around, that doesn't make Mr. Martinez guilty of stealing Mr. Lettner's vehicle. This evidence that ties him to the site of the crime is insufficient corroboration that he was a participant in the crime. And I think that this, and I hate that I'm blanking on the case name now, but it was a recent opinion from the past couple of months where just because a person was at the scene when other people assaulted someone does not mean that that person is guilty of the assault. They just happened to be there. And I would say that, as I said in the brief, Mr. Martinez, I guess, relations with Miss Ivy are after the crime occurred, and nothing ties Mr. Martinez to the death of Mr. Lettner. Thank you.
All right, thank you very much. The briefs were excellent in this case. The argument was excellent. We appreciate that. There's a lot to look at. We'll take it under advisement.